A little early for a Saturday or a Monday. How are y'all doing? Good. Y'all take away anything from yesterday? Good. What was some of the bigger takeaways y'all got from yesterday? None. Yes. Take action. That is probably the one thing that stops most people from succeeding in this business, is they don't go out there and take action. They'll spend 2 years studying it and don't ever do a thing with it. So, what else do we got? Any other takeaways from yesterday? Yes, sir.
Don't be afraid to fail.
Don't be afraid to fail. Failure is important. It really is. So many of us are conditioned to think that failing is a bad thing. You know, failing has its ouches, but if you learn lessons from it and you continue pushing forward, you've got something that comes out of it.
Knowledge is a power. Applied knowledge is power.
That is the truth. Knowledge is not power. Applied knowledge is power. It's very important. Yes, sir.
Why? Why is very important.
I think that's the most important thing. You know, I think that ties into everything else. Like, if your why is strong enough, the failure won't stop you. If your why is strong enough, the action will occur. If your failure is strong enough, if your why is strong enough, the knowledge will be applied. The thing that I have found that is the common denominator across the board that I've seen with most people is that their why was larger than their fear. Like, whenever your fear is larger than your why, you'll never take action, you'll never go, and you just don't have enough pain. The people that I meet that actually just or already got their backs up against the wall, or they put their back up against the wall, are the ones that I find that absolutely win. Like the person that's like, you know what? I know my bills are $6,000 a month. I know I've never done a wholesale deal in my life, but I just quit my job. I've got $8,000 sitting in the savings. I'll figure it out. And they don't. And they lose their house. And then they do this and they do that, but they never give up on it. And then 3 years later, they're millionaires. You know? It's those type of people that are like, F this. This is either going to win or it's not going to win. There is no other option. It's like, I'm going to go out there and I'm going to win. So those are the people that I see that typically win. So moving into today, I'd like to say, everybody, thank you for showing up on a Saturday. I know that y'all got a lot of family. I've got a lot of other responsibilities, so I appreciate y'all for showing up. We're going to be going through transaction coordination. We have the world's best transaction coordinator here, Miss Casey Della.
Hey guys.
She is the founder of Atlas Transaction Coordination Services, and she is pretty awesome on this side. So she's going to co-host with us. We're going to go through, start out the day with thanking Quest Trust for allowing us to have this building, allowing us to have this room. Thank you very much on that side. Yay! Let's get started.
Yeah, this is the fun stuff, paperwork.
Paperwork. So going into it, like if I'm in the field and I'm running acquisitions, one of the very first things that I'm going to do once I get my contract is I need to communicate with my team. So like if Casey is running my files for me, I've just spent the last 3 hours with my seller going through, doing whatever I need to do. Here are the commitments that I promised. Here are the things that we agreed to. Here's all that. I need to communicate with you. So I'm going to sit down and I'm going to be like, all right, so this is why I did this on paragraph 7. This is where I did this and this and this. And the seller has agreed that we will allow her up until the day before closing to move out. Because if you're the one, essentially, what's the role of a transaction coordinator?
Good question, because I think there's a lot of confusion really between what a title company does and what a transaction coordinator will do. And one thing I can tell you is there's a lot of paperwork and deadlines legally that have to be met in order to uphold the honor of your contract. And so you can't treat this as if this is just, oh, if it works, it works. If it doesn't, it doesn't. I see a lot of investors get really lax about it. So a transaction coordinator basically makes sure that everything is met from the time it's executed and signed and becomes effective to when you're at the closing table, wire sent, file closed. So one thing I cannot stress enough is that a lot of people spend so much time trying to figure out how to talk to sellers, how to get the contract, and then they forget the rest. And guys, your transactions are the lifeblood of your business. If you don't have a closed transaction, you have nothing. So you can get really good at closing them with your sellers. Then the other skill set is actually making sure that that money comes to you. So the transaction coordinator oversees all of this. And to just clarify, you obviously legally have to go through a title company or an attorney to get these things done. You know, they're going to make sure that they're writing all the legal stuff. They're getting the title policies that are required or that you ask for, making sure the surveys are ordered, all that kind of stuff. But their job is really just to do compliance. Their job is not to close your deal. Their job isn't to chase additional paperwork. Their job isn't to talk to all of your sellers, and they might. If you have a really good title company, they're absolutely going to assist you with this. They're going to give you the knowledge, but nobody cares about your deal more than you do. So you can't always rely on them to be on the ball. And trust me, I've worked with probably 100 different title companies, and a lot of them drop the ball. A lot.
It happens a lot.
It happens, and that's just because they get overwhelmed just like anybody else. These are really complicated deals on the investor side. So you have to make sure that either you or somebody on your team is actually paying attention to what the contract requires to uphold the integrity of your deal and to protect yourself as well.
Okay. So with the transaction coordinator, a lot of that is going to be communication. You're going to be communicating with the seller, communicating with the title, communicating with the foreclosing trustee, communicating with the banks, communicating with probate attorneys, communicating with the entire process. The communication key right here is very important for me as acquisitions. Like she said, my job is to go out there and get the contract. Once I get the contract, I'm depending upon somebody else to get it closed so I can get paid. Some of the key things from my side of the table that I have seen deals fail very quickly on is the communication between the seller and the buyer starts dissolving. Yep. That seller is counting on you to stop that foreclosure. That seller is counting on you to clear this property and get it ready to purchase. And they're in a scary situation in their life. They're nervous, they're freaking out. They want a phone call every 15 minutes. So whenever I'm on the acquisition side, I try to prep them up front with what they're expecting from my office. I will give you at the very least a weekly update, and depending upon the timeline to, let's say, a foreclosure, I'll give you a daily update. You can expect a daily update from my office. I will be speaking with Casey Della. She will be the one communicating with you. If you have any emergencies, get with me, but all communication must go through Casey. If you have a phone call with me and you ask something of me, it does not count. And I try to make sure that the seller understands that up front. You can call me all you want, but that phone call doesn't count because it is her job to get the title closed. And if she does not know what you asked me, then the communication chain is broke down. So from this point forward, I'm handing all information off to Casey. Casey is your number one and only point of contact. Okay?
And I cannot express that enough because y'all have built rapport with your sellers at this point. I'm a third party that knows absolutely nothing. So I'm only as good as the communication you give me, and so is your title company. You're gonna basically delay this if you don't give us this information. Just to give you a super quick example, I had a situation where we were trying to pull these city liens and trying to get it closed. It was the only thing holding us back. It was a foreclosure. And because my client didn't ask the seller very simply, what is this lien? They basically was like, oh, I paid that off. I'm actually supposed to get a release from the city. And that changed the entire game. So after 2 weeks of waiting, I said, go down to this office right now, request it, and we got it within 10 minutes.
That's awesome.
Things like that matter. So like, yeah, you have to set the expectation for your seller as well as for your team. Otherwise, we're in the dark here.
So when we're just now starting out, we're going to wear all the hats. You're going to be the transaction coordinator. You're going to be the acquisitions. You're going to be the marketer. You're going to be all of these people. But the transaction coordination piece is extremely, extremely important. And with her experience in that, that's why we're talking about it. You had a question, Jocelyn? We needed to get you a microphone. If we have anybody that would volunteer to run the microphone, that would be awesome.
Oh, awesome.
We got a volunteer up here at the front.
Good morning.
Morning.
So first, my question is this. I know most times I already build in the third-party authorization for dealing with banks for foreclosures. So would it also be helpful to have a blanket one for the transaction coordinator if we're going to, have you to fall into that role as well?
Yes,
or will you use the same one?
100%. In fact, if anybody I work with, I give them an authorization for my company, just like you would for a title company. So if you use a title company, that's very common. I always keep them. I keep car files. I think good investors should have a car file folder. And I'll keep authorizations for my usual title company as well as my transaction coordinator if it's a third party. Or anybody on my team to authorize. So, you can submit as many as you want. That's just good to have on backup if you can't get authorization with your seller on the phones.
I may do it a little differently, and I don't know legalities behind this, but my third-party authorization has like 7 blank lines on it. It says the following are authorized to communicate this. And then in print, It shows my name and my company's name and all parties to my company. And then I have like 7 blank lines that I can say, you know what, I might have somebody at the title company, I might have this, and I fill that in. And so that's how I hold, that's how I run my third-party authorizations.
Yeah, you
because,
can. I think you can do it that way. I know some places that will be really particular about that, so it kind of just have a backup just in case. But you know, that's common too.
So mine in actual type print, it shows my name, my company name, and all associates of my company. But then I leave like 7 blank lines for additional people. But that's how I've been running mine.
as long as you name the parties that you need to name, or you can also do a verbal on the phone super quick as well.
So going through the handoff meeting, one of the things after the handoff meeting is we need some level of management to the process. You can't just sit there and wing it. You need to know, okay, these are the 19 things that have to be done on absolutely every single file, otherwise this file does not get closed. And what I mean by that is like, all right, step 1, we need to open escrow. That is like step 1 for me, day 1, get that thing moving forward. Opening escrow, what do I mean by opening escrow? We need to find a title company or a title attorney depending upon what state you're in. How do I know what title company or title office or title attorney is competent for running my deals? It's extremely important. Like she said earlier, an investor file is not a typical file for an escrow officer. There's often a lot of the times significant encumbrances. There's a lot of issues in title, chain of title, and all of that has to be cleared. And I want to make sure that I'm working with the right title company that not only has how to handle all of those encumbrances, but understands assignments of contracts, double closes, and or any creative financing terms that might be included in that contract. So how are we going to find that title company? For me, the fastest and easiest way that I could possibly say is just go to your local Facebook group or your local REIA or your local whatever it is dealing with real estate investors and ask around. Just say, hey, what escrow officer would you recommend? What title company would you recommend? And you'll often find that you're going to find one person's name or 2 or 3 people's name a lot. Who are you going to use? That person. One of those 3 people. Yeah, I guarantee you right now, if we went into one of the larger REIAs in town and just said, what title companies you're using, you're going to hear 2 or 3 common names. That's the title company you use. So moving forward from there, don't let that be a hiccup for you. And I wouldn't suggest going out there right now and calling all of them up and saying, I might get a contract 5 years from now, what do I do? They stay busy, but just know that whenever it's time to get your contract, then call them up and say, hey, I have a contract. What do you need done for me? So what I do is I submit my contract immediately day 1, and I always, if I need to, have my title company file a memorandum for me right then and there. So I have them do that on my side, and I submit all necessary docs to the title company at that time. Now, whenever I'm running acquisitions, I know up front from my experience what my title company needs. If I'm dealing with a house that's going into foreclosure, I need a third-party authorization. What else might I need if I'm going into foreclosure? Power of attorney, possibly. I could also be looking for any information regarding the bank itself. Like, I need to know first position lien, second position lien, third position lien, who the contacts there are, what's the foreclosure date set at, who is the trustee for this file, the foreclosing trustee. There is a lot of extra information. I'm going to get all that while I'm sitting down with the homeowner. Whenever I hand this off to Casey, I'm going to show her the last mortgage statement. I'm going to show her the last 2 or 3 mortgage statements. Whenever I go and I contact the title company, I'm going to submit all that paperwork to them as well, because guess who they're going to need to contact? The bank. If I just give them the contract and I don't give them any other point of contact, who are they going to be trying to call to figure out what banks they need to contact? You. And then who are you going to have to get in touch with? The homeowner.
Yeah, a lot of back and forth for sure. And something I would add to that is something like a letter of intent to sell from the seller in a wet signature is incredibly helpful to add to your documents on a foreclosure, because a lot of lenders do allow a postponement of foreclosure with a contract, proof of funds, as well as a letter of intent to sell. So all it has to literally say is, I, so-and-so, a homeowner, intend to sell my property at this address with the loan number and just a wet signature, and then attach a contract. So if you get that up front, because it can't be digitally signed, you're going to help us be able to stop a foreclosure. So that's just a document I would just write down and make sure that you do on any foreclosure, just to add.
So if I've got let's say I've got an heir to the property and nothing has been done to transfer title. Title is still in this deceased homeowner's name, and we know that the title is still in their name. Well, there's no point in me taking that contract to title and saying, hey, figure it out. I'm already sitting down with the seller. I should get that figured out long before I ever submit it to title. I want to know from the homeowner, was there a will? Okay, was there a will? Was there not a will? If there was or was not, can I get a copy of it? From there, I'm trying to determine who the heirs to that property are and how I contact them. Also, while I'm on the contract, while I'm on the property, I will get affidavits of heirship questionnaires filled out. I don't have a time to sit here and teach everything about probate, but what the title company is going to need to transfer title in the event that there's not a will is I need affidavits of heirship questionnaires filled out. Those kind of are title specific. Some title companies want their specific forms, so I will find out what title company I'm going to work with and say, hey, do you have an affidavit of heirship questionnaire that you personally like to use? I keep that in my card file in my car at all times, because when I'm showing up to a property and then all of a sudden I find out that there is an affidavit required, what an affidavit does is it transfers title from a decedent to the heir. I'm going to get all of that information filled out right then and there, and guess what? That might take 2 or 3 hours. People don't want to sit down and answer all these questions about their deceased loved one, especially when it comes to estranged kids, estranged spouses, all of this weird stuff. Family drama gets involved in this a lot. And then when you say, well, did your father have any other children? Well, yeah, but he's locked up and I haven't seen him in 34 years. Well, guess what? He's still getting paid. And you'll see a lot of drama pop up. And that's why you let this woman deal with all of it. So, like,
I have to say that you're the most responsible investor I think I've ever listened to in terms of you got to get this when you're there. Seller information sheet while you're there, because most of my guys, I know that y'all are like, I don't want to deal with this. I just want to run with it. Well, tough luck. This is what it takes, and you need to be responsible in order to get your steps. I have a lot of people toss me contracts, and I'm like, where is everything else? And so,
what I want to add to that, and I think it's extremely important, is when do you get paid? When you close on the deal.
yes, so do I.
If you don't close on the deal, you don't get paid. And anybody that takes the lackadaisical approach to the contract when they're sitting there at the house and saying, you know what, I'm just going to bet that Casey gets all this figured out for me, is just preparing themselves for failure. I don't know about y'all, but whenever I lose a $24,000 deal, heads will start rolling. This is not a play date for me. This isn't like, oh, I didn't need that money. You want to see me get in trouble? You want to see me get in some serious trouble? Watch my title company mess a file up for me. It is not play day. That's $24,000 of my money that just got lost. So if I am going to depend upon Casey to get this file done, well, then I need to know up front, what does Casey need to get this file done? Experience will tell you that. If I'm at a house and I know that there's an affidavit that's required, I'm going to get that process started. Why? Because she's not going to do it for me. Now, if I give her all of the information, oh, okay. So give me some explanation like that. Let's say I'm a brand new investor and I do nothing for you at all. I just bring you a contract. How does that process look?
Yeah, so if you give me a contract, what we do is we audit it, right? We're going to look through everything. We're going to contact the sellers and probably have to get from them everything. But if they've already gone through this with you, this is just a burden on them. So we don't want to double, we want to make this as easy as possible for them. Now, if you do just hand it to me and you have no idea what you're doing, I'm going to open title immediately, and I'm probably going to rush title, right? Because I don't know the situation, and you clearly don't know the situation, and so I'm going to rush it so I can look at Schedule C and see what's going on. And if I need to, I have some clients, for example, all they do is affidavits of heirship. I mean, almost every deal needs one, and so we just have a routine. When I get it, he goes, hey, Casey, can you get this for me? They're expecting your call. That we can handle. We know we have to do it, and so we can do these things and do them for you, but we have to know. Otherwise, you're going to have to wait how many days before a title commitment comes back, and that is just time, because an affidavit of heirship, once completed after the seller does it, can take a couple days for the attorneys to draw up. Then it can take a couple more days to get the witnesses to notarize it. So you have to keep in mind your timelines and how you can help close those gaps by doing it. So yes, we can. Just like title pulls a lot of the weight for a lot of people who don't know what they're doing, but do we prefer it? No, because we can't be efficient when y'all don't do your side of the job.
That's a great way of putting it. So, yes, sir. Oh, let's get a microphone. Thank you, sir.
Just a quick question. You're trying to get all the affidavits signed when you're there. you're not the notary. How do you get the notary
Affidavit
done?
of heirship questionnaire. So
Yeah,
the
questionnaire.
questionnaire will ask
It
the
doesn't-
34 questions required to draft the affidavit.
Okay.
And so that way, whenever I show up with Casey or I show up with my title, I've already got that questionnaire filled out, so 90% of it's done. There might be a couple gaps that need to be filled in, but now that paperwork can be handed straight off to the attorney. The attorney will draft the affidavit of heirship, and then you'll get them. So like for me, if I go on a property and I know that an affidavit of heirship needs to be filed, I'll take that questionnaire and get it filled out right then and there. And I can oftentimes have the affidavit of heirship questionnaire filled out. The very next morning, I'll submit it to title. By the end of the day, I've got the questionnaire or the affidavit of heirship completed. I'll have a notary out to the witness's house, and within 24 hours, I've already got title ready to clear. Why is that important? The other day, it's a payday. The other day I asked, if there's $100,000 laying in the middle of the road, how long would you let it sit there? That's why I try to make sure that these things happen and happen fast. Like just because that seller signed a signature with me does not mean they did not sign a signature with somebody else 24 hours later. It does happen. And that is not a fun thing to find out when you're banking on getting a $62,000 check at the end of the month and it just disappeared on you. Why did it disappear? Raise your own hand. There is no reason why it disappeared other than you. If somebody else was able to get that contract and close it before you did, and you got it first, that's just a sign of how you're operating. It's sad to say it that way, but it's important. So when we do that, we do submit this title and all the paperwork that we've acquired over to the title company. One of the very first things that they need to do is pull an abstract or a title commitment. Can you explain a little bit about what we're going to be looking at on that title commitment?
Yeah, absolutely. So just an FYI, if your title company does not get you an abstracted title within a few days, push them. Request why they don't have it. I have seen them take 3 weeks before, which is absolutely unacceptable. It should never take that long. They can rush these. You just need to let them know. And so just keep pushing. I always say after 2-3 days, send them an email. Hey, do we have title in? A lot of times it's just on the backside and they haven't sent it to you yet. So make sure you know within a couple of days to ask them.
So let me explain what an abstract
Yes,
is.
go ahead.
So, or if you were about to.
Oh,
So-
no, I mean, go for it.
So an abstracted title is they're going to just run a preliminary search of that property address and that homeowner, and they're going to try and find out any possible liens that are against the property, any encumbrances, any breaks in the chain of title, any issues with the title. They're going to try and figure out anything that could possibly cause this property to not transfer. And that should show up in an abstract of title. That's what they're going to call it. That's what I've always called it. I can normally get my title company and get that with me in 24 to 72 hours. There are some title companies that will charge for an abstract, $50, $75, $200. What I would say is that if you've developed a long-standing relationship with your title company, normally that abstract will be free up front. They'll just get it to you, especially if you're turning volume with them. I always have my title company, I say within the first 48 hours, I want my abstract.
Yeah, 100%. Demand it. You should.
It's like if I'm working with you, it's a requirement. It's like if you can't do that for me in the first 48 hours, we don't work together. That's just the way it works.
Keep in mind they're part of your team just like anyone else. And if they can't meet your expectations, then just find somebody else. And always have a few on hand because they do get busy. But when you do get your abstract back, y'all read it. It blows my mind how many people don't read abstracts. It's not super complicated if you know that it's A, B, C, Ds of title in Texas. Texas is a little bit different than other states, but you know, you're going to look at A, that's literally just going to be actual facts. It's going to name the parties involved. It's going to name the purchase price. It's just going to be facts about the transaction.
Verify that.
Yes, because
Verify
a lot
that.
of times it's wrong. So make sure
We got time for some stories? I think we've got time for some
I literally had
stories.
one recently where just the purchase price was incorrect. And these are technically associated with your policies. So you have to just make sure that the right parties are involved. And then keep in mind, if you're assigning your contract, that's going to change. So you want to make sure that you've got the right people on there.
Y'all want to hear a funny story?
Always.
I don't know if you know Ronnie Walker. Ronnie Walker was Grant Kemp's business partner for a long time. He went out and he got a property under contract from an absentee owner, 123 Main Street. He made it to title, got title clear, got title commitments, got the HUDs drawn up, signed on it, funded the deal. 3 to 4 months later, whenever he turned around to resell his rehab, he found out he did not own the property. What he did own, in fact, though, was the seller's primary residence. They went through And the title commitment, the HUD, the title, 100% of the transaction was the homeowner's personal residence, which was like a $350,000 to $400,000 house.
Not a totally bad day.
But now he's got to unwind all this. So now it's like, obviously there could have been a lot of issues there, but all of that, even from an experienced real estate investor, working with an experienced title company, working with a landlord, they all made it completely through title, and that man purchased the primary residence of that landlord. It is very important to verify the details on this paperwork.
Yeah. And like I said, like y'all, it's your deal. Like you can't rely too heavily on everybody else. Just scan it, know what you're looking for, and it only takes a few minutes. I mean, you should know what's involved. But yeah, after Schedule A, you're gonna look at Schedule B. Schedule B is basically, we call it buyer beware. It's basically all of the things that aren't gonna be covered in a title policy. So things like easements, things, plot lines that you can't change, or whatever it is that shows up for that particular property, sewer lines, you name it, it's just gonna be on there. Not covered by your title policy or your insurance, so keep that in mind. Schedule C is what you really want to look at in Texas in particular. Other states don't necessarily have Schedule C. You'll find this information on B. Oh no, by all means.
No,
You're running this show.
I've got questions. I know I've got questions for you because
Yeah.
I've never transacted outside of Texas.
Yeah.
Does this look different across the United States?
It does look different. Texas has really interesting laws because of the nature of our history, and that we actually have very strict legal laws when it comes to closing title. So our schedules are a lot longer. Other states don't have Schedule C at all. You won't see it on there. It's literally just going to be Schedule B and B1 and B2. Between B1 and B2, you'll basically see other things, and this is. Some of them might be slightly different. I'm only in about 5 or so states that I've seen, but yeah, it'll basically have the same information. The information isn't different, but some states, for example, require that you run things like they run the buyers and the sellers' names through a database that shows that there's no judgments. So they get a specific run separately, and there's an attached document that shows that it's clear or not clear.
Okay.
And then they'll also run them on any kind of city and tax liens. I know Philadelphia does this, New Jersey does this, where it'll basically run them through a database, and it will show if you're delinquent on any kind of city water or anything like that. Their water systems are so screwed up over there. Pennsylvania is a whole nother beast. It is I've seen water bills that are up thousands upon thousands upon thousands, and half the time they won't insure properties if a meter's missing, but that's beside the point. But you have to know what to look for in your state and know common problems that you're gonna have and what title is going to look for and not look for based on whatever the laws are.
Okay.
So in Texas in particular though, Schedule B is gonna be clear, that's just what's not covered. Schedule C is what we call clear to close. This is what you have to clear in order to close. There you might see things show up like we have a vesting issue. By vesting, I mean we have a name issue, meaning whatever is on title is not matching what's on the contract, or maybe someone had a name change, or maybe they're working out of a different company. Whatever the point being, you have to usually verify that this is the correct party involved. You're going to see what we call vendor liens on there. A vendor lien is just a mortgage. So you'll be able to see if there's a mortgage attached to the property. I've seen people tell me they have no mortgages, and then up pops a vendor lien on there. So you need to look at that. You'll see things like judgments on there in Texas. You'll see, and a lot of times you'll see the amount. Not always. Sometimes you have to do a little more digging and get payoffs from them. But you will see everything that absolutely has to be cleared. Some title companies will review this for you and tell you, hey, we have title back, these are our issues. A lot don't. A lot of them will just say, here you go, please review, and they'll send it to your sellers as well. And guess what? You're gonna get a call from your sellers being like, I don't have a judgment on me, I don't have this wrong, like, this isn't me. And sure enough, you're like, actually it is, And sometimes it's not. That's really important too. I have had more times than I can count where a judgment shows up against a name because it's so similar, and it actually isn't them. So you would have to work on clearing the name or verifying that it actually is not them of which the judgment is associated with, but you still have to do that work.
So on my side, I feel like I've been spoiled. I'm very
You have
selective
been.
of the escrow officers that I'll work
Yeah.
with. Anytime I get my title commitment back, they already go through Schedule C and they highlight everything that they need help with. It's like this encumbrance, and this encumbrance, we need to verify. We need to figure out what's going on there.
Yeah.
And one of the things you were saying is if your seller's name is John Smith, you're likely going to see a lot of things showing up in that Schedule C that's not directly attached to your seller.
Yes.
But since it's such a common name, a lot of things will pop up and show up on Schedule C. So like she said, we do need to verify who the homeowner is so that we can get all that removed. And one of the things that I require of my title company, and I've worked with my title companies for quite a long time, is outside of mundane, typical communication, all communication must go through me. They don't call my seller and be like, hey, you know, we've got all of these liens showing up on your property. You talk to me about that first. If I was with the TC, like I had my TC at the office, all communication went through my TC, and my TC was like the only point of contact with the seller. So that way the title company wouldn't tell the seller something, my TC tell the seller something. I'd never wanted miscommunication to happen, so I always tried to maintain the line of communication through the TC.
Yeah, important too, because it confuses your sellers. My title companies, any title company I work with knows go through me and me only, and my clients know that as well. I don't even let my clients talk to them half of the time because my clients aren't involved with the 50 emails that I've just sent all the time, right? That's the whole point of them hiring me, is that's just clogging up their inbox and their time. So yeah, that's a really, really good point. I had a property, honestly, recently that showed up 37 judgments against the owner of the property who was deceased, and her daughter was taking care of it. And we had to go through 37 judgments to make sure it wasn't them and verify. So
Fun
it
stuff.
happens.
So communication, I think, is the primary piece to the escrow and TC portion of this business, and you need somebody that's paying attention to it from beginning to end. It is a vital piece of this business, and if it's not handled and handled well, you will find a lot of times you're going to lose your contract. So when we pull Schedule C, we're going through all these potential encumbrances. Here is a small list of common issues that you will find. If it's in pre-foreclosure, there is a decedent in title. Now, what do I mean by decedent? There's two words that people often confuse with each other. Descendant, there's an N hiding in there, and decedent. Deceased, decedent. The decedent is the dead person. The descendant is the heir to that dead person. Well, if we find a decedent in the chain of title, we need to clear that person out of title. We've got, I said quiet claim deeds, but that should have said quick claim deeds. Quick claims in the chain. I don't know how this goes across all 50 states, but in Texas, we don't like quick claims in our title. Like if there's a quick claim in the chain of title, oftentimes your escrow officer will require that quick claim to be transferred over to a special warranty deed or a warranty deed or a general warranty deed. Why? I don't know. I just know from my experience that they don't like quick claims, and if there is one in title, it messes my day up. I don't like it. Abstracts of judgment. You know, let's say that somebody went out and did some work for somebody and didn't get paid. Someone might file a lien against that property. Mechanics liens. Somebody installed an air conditioning system and they didn't get paid for it. Common seller names. You do have a John Smith on there. You're going to see a lot of judgments coming back against that property that might not necessarily be attached to John Smith. Tax liens, utility liens, mowing liens, and child support liens. Now,
Those are fun.
good times. Child support liens can be fun. But let's talk about all this for a second. I'm sitting down with the seller. Do you have any idea how often the seller notifies me of all of this? I'll ask, hey, do you know of any liens against the property? No, we're good. And then I get the title and there's like 37 of them.
37.
It's like, well, that's not what we were planning on. So once we get to this, it's going to become our job to start figuring out what's going on. Now, I cannot speak across all 50 states, but what I can speak on today is Texas home ownership laws. We have probably some of the tightest homestead laws in the nation. I think Texas and Florida are some of the best in the nation when it comes to our homestead rights. If the property is a homestead, here's a quick tip for you, and you should be working with a skilled and wonderful title company. I often find that your title companies may not be aware of this. And that's why I like to work with a skilled title company. If it is in Texas and I have a homestead, abstracts of judgments cannot be filed against a homestead. And guess what? If someone does file it, what do? You get it removed. So a lot of the times deals that I would close would be deals where other people passed away or failed to close after contracting it, and I'd go contract it and I'd find out, okay, the reason they were failing to close is because they had all these judgments against the property. Well, that makes me really happy. Well, I'll contract the property for the price that everybody else did, and I'll go clear all these judgments out for nothing. It doesn't cost me a dime to clear them. And now I'll create the equity I needed to purchase the property. So in Texas, child support liens, abstracts of judgments can very quickly get pulled out of title. Very quickly get pulled out of title. So if you ever run title and you see those on there, instead of saying, oh, I've got to get these paid, you might say, oh, I've got to get these cleared.
That's a homestead.
It's a homestead. Now, if it's the rental portfolio, no.
Yeah, and I was going to say, a lot of title companies have office policy that doesn't follow actual law. And so I can give an example on this one, particularly for an abstractive judgment that was on a property that was passed down to heirs. One of the heirs had a judgment against them. It wasn't a huge judgment. It was only about $5,000, but that can make or break a deal. And one title company would absolutely not close on this property. I asked them for a homestead affidavit because the guy didn't own a residence, and in Texas, it automatically becomes your homestead when you don't have one. So I had to pull it to a different title company, and they were perfectly happy to file an affidavit of homestead and able to do a partial release, meaning it doesn't get rid of the judgment, but it does remove it from the property, and it's still associated with the person. But it allowed them to clear the title on the property. So keep that in mind too, where if you do have it passed down to an heir, and that's the case, there are little things like that that you should ask your title company whether they'll do or not do. And if they won't, ask another one because it's law. Like, it's just the way it works. So,
Jocelyn had a question, and while we'll get the microphone. Okay, we need a microphone. Oh, hold on.
Well,
Microphone's on
we'll
the way.
do one for the internet while he's running over there.
Okay.
As far as Ivory Clark was asking, how do you know when an affidavit will be required, and when is it worth it?
So affidavits are for transferring the title to the heirs. So if you're showing up to a property and the owner of the property has died and they have not transferred the title, you're either going to need to run a probate or run an affidavit of heirship. Most real estate investors will elect to run the affidavit of heirship. There will be a few small cases where you're not allowed to run affidavits of heirship if the estate is too large, if there's not an agreement over whether or not this property to transfer, if there's arguing or if there's missing heirs. Then we're going to have to go through and do probate. But if we know who all the heirs are, everyone's in agreement of the sale, then we can move forward and get an affidavit of heirship filed.
And a quick note on that one too. Keep in mind that you might not always want to do the affidavit route, even if it's easy. For example, if they have estranged spouses or kids and there's a will, you're probably going to want to probate that, because if you go through the affidavit and they now have rights to your property that might go over the will and might not honor it. So keep that in mind, that it's a strategy too about who's involved with getting the proceeds.
The finding out if there is or is not a will is important. Like finding out if there is or is not a will, because the will might say, I have 19 kids outside of my marriage, but the only person that's going to get any of this is my only legitimate child of this marriage. Nobody else gets anything. So a will tell you who that is. Now, there have been times where I'll show up on a property and there is a will. And the will says my 2 kids get it, and I have no other kids. And I'm talking to both of the kids right there. Do I have to probate it? I do not. I can go through and do an affidavit of heirship and just make sure that it follows the path of the will, and my title company will close it like that. That'll save me the process of a probate, and then I can just get the affidavit of heirship done. It costs me about $150. I'll do my affidavit of heirship, and I'll get child transferred within 24 hours.
Beware of unknown children, though.
Uh-oh.
It's happened. My husband and I had a property where literally ready to close, everything's going, title did another check or something and found out there was another child outside of marriage with the same name as one of the other kids from a different marriage, and they didn't know about each other because they thought their parents were divorced and they weren't.
Wow.
Officially. And so this random person shows up, and guess who has rights to the property now? So
That's wild.
Just make sure you check, because you never know what families have between them and their secrets.
I have something to laugh about on that one, because I'm sitting down in Dallas with a homeowner, and sole heir to the property, mother has passed away. We're sitting there in her mother's living room, and we're getting the paperwork put together. I always start asking chain of title questions after I get a wet signature, because normally if I start asking that before the wet signature, the chances of me getting that wet signature decrease. So I always get the signature first, and then I start asking chain of title questions. Now, one of the things that I noticed while sitting at the table with the sole heir of this property is all of the family photos around the house. that show multiple siblings. So after everything's done, I'm like, hey, you have any brothers or sisters? No, I'm the only heir. I was like, for real? And like I start asking more and more questions, and then finally I have to call her out on it. I'm like, who are the other kids in all these photos? And then she's like, oh, well, that's my brother, but he has nothing to do with this. Oh, and it's like, no, they do have something to do with this. I appreciate you trying to circumvent them on this, but no, it is important. So these sellers will lie to you. These sellers absolutely will lie to you. So be aware of that. We had a question here.
Yeah, my question was, why do some title companies ignore judgments and some
It's not
don't?
that they ignore judgments, it's that they require that they be cleared rather than go through a homestead affidavit. And the reason for that being that I've seen in the past is, I don't know, maybe somebody in their office didn't do it right, or they're a larger title company where they just have policies in place where they don't want to take that risk for whatever reason. I think a lot of it too is just them being out of touch with, honestly, property code in Texas. I think people just kind of try to keep it generic and not get too detailed, and because they're trying to be efficient as a title company and they don't want to go through extra work to do it. And I can honestly say I've had a title company, a very well-known one, that refused to close on this, and the other one insured it no problem, and the attorneys started bickering at each other, and he was like, I'm insuring it. So again, it can just come down to office policy that they're just trying to, like, you know, protect them.
I was closing for a long time with my preferred escrow officer at Stewart Title. I follow my escrow officer around. I'm not married to a title company. I'm not married to Chicago Title, Stewart Title, Fidelity. I'm married to my escrow officer. Yeah. So I was closing with her at Stewart, and Stewart had a lot of policies in place that would not allow her to operate as she typically would. Well, I had to stop operating with her because of Stewart Title, and I went to another title company. The other title company I went to is a dirty name around here. I don't want to talk about Nancy Carroll, but it's fair for me to talk about her. She's in federal prison right now. So that to be said, she was a very, I hate to use the word competent, but she was a very, very competent attorney on that side. She knew the Texas property laws extremely well, and she had a draft form letter that basically said, Texas Property Code section blank, 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 blank says that any homestead is free of blank, 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 and if anybody encumbers a property via this method and allows the property to go to foreclosure, they stand all liabilities of that foreclosure. You need to release. Texas law says you have 72 hours to get it done, and if you don't, I'm suing you. Well, that letter that she provided for me has worked numbers for me getting abstracts cleared from my title. And then whenever I went from her title company back to my preferred escrow officer, because she switched from Stewart over to Alamo, when I went to Alamo, I had to kind of educate her because I was newer in the business. I was not aware of all of that at the time. And I was working with her, and Schedule C came back, with a bunch of abstracts and was like, just use Texas Property Code blank, 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 and get all that removed. And she's like, what are you talking about? Yeah. Well, I had to educate. Don't expect the escrow officer to know more than you do. Yeah. While you would want them to, sometimes your escrow officers are just like you. Like, I, with as much experience as I have in real estate investing, do not know even 10% of the entire business. Like, as much as I know, I'm about 10% in. Like, I will forever be a student of this industry. So title company's no different.
A lot of, little things too, like for example, a tax lien, right? They have an expiration date on them. You know, you look at the dates. A lot of times your title company's they're like, well, you have to clear this tax lien. And it's like, well, actually it expires in a month. Right. So that's going to change the nature of how you close this deal. Well, they might not be paying attention to that. And then if you want to try and say, well, I want to go and try and argue for a partial release, where there's rules to that and how you go about doing it and how you draw attention to it. So having knowledge about all of these types of things that can encumber you and the ways to navigate them is also something a transaction coordinator really helps with. When your title company, like he explained, is bound by rules and doesn't know how to do it, or is just lazy, to be quite honest, at the end of the day. There's all of those factors involved. So like I said, you know, you can't fully rely on your title company if you don't have the knowledge yourself.
Any other questions while we're on the screen?
I had one more question.
And he has the mic, so.
Okay.
Yeah. Earlier you had mentioned a certain document required a wet signature. So when it comes down to wet signatures and electronic signatures, how do you kind of navigate that?
You're probably going to learn as you go on that. There's kind of a long list. Anything that has to do with a lender is always going to be wet signature. Just always get a wet signature because they're going to always compare it and make sure there's no fraud going on. It's very particular because you're getting personal information. So anything with lenders, wet signature. With title, anything that has to be notarized, wet signatures. And then that's kind of pretty general. The rest, for the most part, will be electronic, but always ask. Always clarify if your title company is asking for a signature on something, whether they want a wet signature or a digital.
I do. 2 questions. First question is, can you give us other examples of the extracts of judgment? And then my second question would be, on the tax liens, do they always have to be paid off, or is there a way to actually get those removed so that they can be attached to the homeowner, like you were talking about with the child support?
Yeah, so I'm definitely not an expert on tax liens. Attorneys are usually pretty good with this, but what I can say are some of the federal tax liens. Well, the tax liens are what we call like super liens. They tend to supersede everything, and you really can't get them removed, but they have expirations. So that's why I say pay attention, and it's rare the IRS, I mean, they're not the most put together organization that they're really paying attention to it. It's incredibly rare that they'll renew. So a lot of times you can wait it out. If it's early on in the game, you are likely going to have to deal with it. I don't know if you have more insight on partial releases or anything, but I haven't had them in my experience.
With tax liens, like city taxes, I've never had any luck at all getting a city lien
Never.
removed ever.
City liens are impossible.
Now, IRS liens, like it kind of almost becomes a short sale with them. Like depending upon how much they are owed or whatnot. Let's say you have it under contract for 70 and the seller is due 20 back at closing. Well, let's say that the IRS has a $35,000 lien that puts it over. Well, what I have found is that you have to, if too short an IRS lien, it's like a 6-month process. You have to file for and then they send out an appraisal, they do all of this, and they try and figure out what the value of the property is, and then they'll do a partial release at the end, but it's not fast. It's like 6, 7, 8 months. And it's,
Yeah.
now with child support in Texas, I have seen child support liens get removed within a week.
Oh, and you can negotiate with them all day. I mean, you can even just say, hey, I'll give you $1,000, and they're like, done, because they don't care at the end of the day. But an example on the tax lien as well, you can also get a partial release as long as, and which is sometimes a little bit quicker than that, maybe a month to 2 months if you're on top of it. But the seller can't be getting anything from the sale. So there are conditions depending on how you deal with it.
I got questions for you on that because they'll do a partial release on a tax lien. What happens
It's
to the
been
deficiency? Does it carry on to the new buyer?
Yeah, so a lot of
Stays with
times
the
it stays with the homeowner, but maybe the partial or whatever. So it just gets released from the property and will sometimes stay with the homeowner. But as long as they're not getting proceeds from the sale, they will remove it from the property.
Well, that's cool. I learned something
Yeah,
today.
and it is a process. Like you do have to go through a bunch of hoops. It's never fun to deal with the IRS. So again, it's like get all these documents in and then wait. And it's like hurry up and wait for everything. So again, just make sure if they're not making anything. And there's no way around that. You can't have something coming out of the HUD and then say they're not making anything, it's going to somebody else. They're not going to see it that way. It's got to be 0 on there.
All right. We had a couple other hands pop up for questions. We've got one over here, one over there. Let's just kind of move the mic around the room. Okay, the mic's already over there.
A question on the wills. After you have closed the transaction, then it pops up. And normally title insurance, they have some sort of waiver signed, regards to things that pops up later and all that. How do you handle those? Does a title company, the title insurance, does it have to cover that, or how does it work if it pops up later?
I'm sorry, I'm not super clear on what you're saying pops up. On a will?
The will at the time of everybody searching and all that, since if there are a lot of them, they don't file it. And if it pops up later, what happens then?
Oh, you mean like after
Closing,
is
a will
after
pops
closing
up.
and a will pops up?
Yeah.
Good question. That might be a question for an attorney. I have never had this situation. I
never
have
had it
had
either.
wills come up, but just with the affidavit and probate situation I talked about, I've never had that happen. In the event that would happen, I would assume an attorney would have to get involved, and you would basically use title insurance because your title insurance is in place to basically cover anything that might pop up that might happen down the road.
And if the title company does have some sort of indemnification clause saying that I am closing this based upon the information y'all have given me, if any of the information y'all have given me turns out to be false, then it's on you. Then I'd say it moves to litigation at that point. But I've never dealt with it, so like I've never seen that happen before.
Yeah, and if it doesn't pop up beforehand, chances are that it's probably not going to, because, I mean, most people lose documents and they're not paying attention to it. I mean,
So while the mic's moving around, there was a story here locally about 2.5, 3 years ago about a homeowner or about a recent investor here that purchased a house from the homeowner, and then after closing went by and after the remodel started, they found out that the homeowner was still in the backyard, buried.
oh, yes.
Yes. So like sellers will lie. The person that he contracted the property from was actually the murderer
Oh, that's right. I remember this one.
and was
Real
posing
estate is
as the
fun,
seller. And the actual homeowner was still in the backyard, and they realized that after the odor started coming out. So this can get really crazy. But fortunately for him, it was title insurance, and there was a lot of stuff going on there. But yeah, it can be really bad. Like, sellers will lie to you. You have to understand that sellers will lie to you. Yes.
I had a question about probate, wills, and then what is it called? Affidavit of heirship. Like, when do those things come into play, or does something like supersede the other, or are they like equivalent to each other?
It depends on what you have. So you have to ask your sellers, is there a will? Period. I mean, is there a will? If there is a will, look at it and see what goes to what. If there isn't, and there's siblings involved and all these things, then if there is no will, you're going to go through the affidavit route. So no will, you're going to go through affidavit. If there is a will, you're going to ask yourself, do I want to probate, or are we going to just do an affidavit if nothing's been started? So it kind of depends on where they are in the process. Some people have already started probate, and so you're going to have to wait for that process to basically verify who has authority at the end of the day. So does that answer your question?
Yeah,
Unless
just
you have more to
depends.
add to that.
If there is a will, then you have the option of going that route.
Yeah, you can go either way.
If there is not a will, you pretty much have to go. You can still go probate or go straight to the heirs. I mean, the only way to go straight to the heirs is if it meets the requirements for an affidavit. And I don't remember the law, but it's something along the lines of like, it has to be divided up per the intestate. It's called testate or intestate. Testate means with a will. Intestate means without a will. All states should have what's called an intestate law. An intestate law says this is who property goes to in the event of a death. It goes to siblings, it goes to brothers, it goes to children, it goes to grandparents, and it goes in a specific order based upon timelines. So you need to know your state intestate laws. I would always keep in my card file an intestate diagram, because in Texas it goes down to the kids. If the kids aren't there, it goes sideways to the brothers, sisters, and wives, and then if no one's there, it goes down, up, sideways. It goes down to the kids. If there's no kids, it goes up to the parents. If there is no parents, it goes sideways to siblings, and then it starts getting further and further out from there. So I know what the intestate laws are, and so if I have a death with a will, I can look at the will and say, does the will transfer the property to the heirs as they would go in intestate? I'm probably confusing people. And if it does, then I just go straight the intestate route with an affidavit of heirship. If it does not, then I have to probate the will.
Yeah, it gets crazy. So yeah, a chart is really helpful to have, because then you know what questions to ask. They're not going to just come out and tell you all this stuff. So you have to probe a little bit.
Okay.
The microphone.
Let's let the microphone. Okay, we got a microphone here. Let's take one from here. Well, then we'll get one from the internet, and we'll come back over to the other side.
Okay, so I had a property that sweet little old lady, her mother died, left her the will. She couldn't find the will. She had 4 brothers and sisters left, and then 2 had already passed, and they had kids. I couldn't get anything done because we couldn't track down everyone. I tried to track down everyone. I tried to offer money to. Now, when I took it to close, or when I took the title or the contract to the title office, I was trying to offer everyone a payoff. Is that something you can do on a contract or an affidavit? Offer specific amounts of money to heirs to give up their rights to the property?
So I haven't personally done that. So I
You
can't
can.
speak on that.
Yeah, you can. You can do that. You can just, but now they're always going to want something in writing, and you can. Keep in mind that a contract and any paperwork you have is just a roadmap for title. They're going to act according to your contract. So if you advise them, I want to pay this part. I know I had a situation basically where they had several heirs, and she was tracking them all down, and she basically offered them $1,000 each in order to sign off on the property to allow one single heir to sign. And so we ended up sending out notaries to 5 different people. And of course, 1 or 2 of them are always like, well, how do I know I'm going to get my money? I want my money before I sign. Well, I'm sorry, this is not how the law works. So, you know, sometimes she'll write something in writing quickly, like an amendment or something, and then you can give that to title, and title will pay that out either out of the contract and let title tell you, say, hey, can we do this? Because it depends on what the proceeds are and what the numbers are. If there isn't enough money in the deal, you might have to pay them out of pocket separately. So we ended up having to pay them out of pocket separately because there wasn't enough room in the cash out, basically. So you can do it, you just have to make sure you have your writing done correctly.
Hey, good morning.
Good morning.
Oh, sorry, it's me? Okay. Yeah, I have a quick question. Say that at this point, we're assuming that we already have, of course, the deal under contract is with the transaction coordinator and the title company, correct? All this is happening. And if this is something you're assigning, right, and wholesaling to somebody else who's going to rehab it or keep it or whatever, and then you took a non-refundable deposit, and then what if some of these items can clear? And you can close, and then the buyer is out there, you know, it's like,
Let me answer
what
this
happens?
question as clear as possible. Let's ignore that non-refundable deposit word. Non-refundable is refundable. Like,
Almost
just because you took that non-refundable deposit, if you can't clear the property to give to them, you refund the money. Like like there's no way in the world I'd be able to stand there in front of a judge and be like, Judge, I got the non-refundable deposit. I was unable to transfer the title, but I kept his money anyways. It has to be refunded. And the reason I'm saying this is because I hear a lot of people like, well, it's non-refundable. Well, you didn't give them the property. Like, if you don't give them the property, you give the money back. And the reason I get so serious about this is I see a lot of people that they'll get that non-refundable deposit, and sometimes they'll have it paid directly to them, and then they spend it. And then after they spend it, and then the title's unable to close, they don't have the money to give back anymore, and then they start trying to argue, oh, well, it was non-refundable. F you. Like, it is refundable. Like,
Look at the language in your assignment contracts and whatnot. It requires clear title. Like you can't. That's just unethical. I don't even.
So of course the money goes to the title company.
So that depends upon the wholesaler. So sometimes the non-refundable will go to the escrow to be held in escrow. Me personally, I would not accept that. Anytime I would assign a contract, the cash came straight to me because I didn't want to get into an argument with escrow as to whether or not they failed to perform or not, and I'd keep the cash up front on my side. So my assignment contract said that the non-refundable deposit would pay directly to me, and if I had somebody that was not willing to pay it directly to me, they didn't get my property. But that's me. Now, if you're brand new in this business, you might not be able to pull that off. But for me, the non-refundable came straight to me, and I wouldn't accept it any other way.
And if it couldn't close, then you would refund it.
Yep.
Okay.
I would, but what I didn't want to have is if my buyer failed to perform, I didn't want to argue with escrow as to whether or not they're releasing it to me or releasing it to that person.
Yeah, because escrow is going to require certain forms, signs, things like that, and it doesn't matter who's right or wrong. They're neutral. They're Switzerland, so they can't bet for you. You have to do it.
Typically from contract execution to clearing of title and closing, how many days do you give yourself? Once you're there with the seller, okay, here we are, we can close.
With me, I'll tell the seller I can close typically within 5 days if there's nothing abnormal on the title. I can get an abstract back within a couple days, get all the paperwork drafted within a day. I could probably get it done in 3 days legitimately, but within 5 days I can get it done if there's nothing abnormal on Schedule C.
I would say a really good way to cover yourself is always tell your sellers, I can close it. However fast you think you can close, tell them after clear title. I can close within 7 days after clear title or whatever. If you say that, then you're protecting yourself based on anything that comes up. I have one client that puts that, they always tell all their clients that, and the way their contract is written is they're closing X amount of days after a clear title, and that could be an arbitrary date because it just depends. So that protects them. It kind of keeps us from doing 5 million amendments, and then they always try to close as soon as they can.
I like that clause.
It's a great
That's
one.
That's gonna be my new closing date.
I got tricks.
I like that one. I like that one. So for anybody that didn't catch that, your closing date says 7 days after clear title. I like that.
Yeah.
So
And I've seen it literally save a lot of deals.
Can you execute a contract with that language?
Can you what?
A contract with that language?
I mean, yeah, you can. I mean, listen, I'm a licensed agent, so I use truck forms. But if if you're not, you can make and do whatever you want, and you can write it that way. You can write close date just like that on every single contract if you want. I mean, it's up to you. You could write that into a truck contract as well. Just write in the special provisions.
Hey Daniel.
Yes.
Before we move on to the internet question, talk about the square.
the square. So that was a foobar, but yeah. So the square that you can take credit card payments for. So whenever I was doing a lot of assignments, what I would find is I'd have several people at the house, and I would get interest, and the people would want to buy, but I would require a cashier's check to lock up the contract. I would not allow anybody. Some people will say, you've got 24 hours to get me that money. I would not give them 24 hours to get me that money. I would not execute an assignment of contract until there was a $5,000 non-refundable deposit in my hand. So what I would find is I'd have 4 or 5 people all interested, and then you know what? I wouldn't get the deal done. So what I started doing is I had talked to Stripe. I got one of the Stripe readers, and I'm like, whoever wants it first, give me your credit card.
I love that.
And I sat there with 17, like within 3 or 4 days, I had 17, I remember it was $17,000. I had $17,000 in that Stripe account within like 3 or 4 days of assignment fees that I'd received, not assignment fees, non-refundable deposits that I'd received. And then I got an email from them saying, we're freezing your account due to potential illegal activities. I'm like, what? What are you talking about? And they're like, we need to prove that these charges were legitimate. Show me any paperwork showing that this were allowed. So I sent them all of my assignments of contract showing the non-refundable deposits, and they're like, yeah, we're not accepting that. We're going to hold all of this cash in escrow for 90 days. If there are any claims against this cash in the next 90 days, then it will be removed. If not, we'll release it after 90 days. So I had to wait 90 days with all that cash tied up in a escrow, and kept it moving forward. So I wouldn't do Square anymore.
But the main point of that was it went straight to you at the doorstop versus.
Yeah.
It literally, it went straight to me. Like I'd get them to pull their debit card out, their credit card. I was like, give me the money. But
I mean, you definitely get points for creativity, man. You've got some funny ways of doing it.
But I didn't like that 90-day escrow.
Ooh, that's tough.
As far as pulling research, do you have to have a contract to do property search, title, to see any liens issues? Deed is transferred without guarantee, or can you check before you even have a contract?
I think you answered this in that, if you have a good relationship with your title company, a lot of times they'll run preliminary title searches. I know in other states, I have some of my clients request just a partial, and so, just a partial to see so they're not, running the whole report. You can do things too, like if you want to subscribe to things like data trace or whatnot, and you can also do it for free, like through
County records, Rome.
County records. It's a lot more tedious, but you can do it. I mean, you can search these things. It's all public record.
When you have judgments, how do you clear them?
It depends upon the state, depends upon the judgment, it depends upon, homestead or non-homestead. But if it's a Texas homestead property and there are abstracts of judgments against the property, I had that form letter, and it just basically said the law and basically told the person that filed the judgment, you either remove it or you're getting sued.
Yeah, I have a situation in Arizona actually where we have the judgment. We actually are going to pay the judgment, no problem. We're not asking for a release. It's the wife, and it's a deceased wife and a husband. And the attorney just won't give us the payoff. Why? Because the wife was the last name on it and won't talk to the husband by any means at all. And we're trying to pay them, but we couldn't do the homestead for them. For whatever reason, their laws are a little bit different. They're not as strong as Texas, and so they didn't qualify for the homestead. So here we are, stuck in a contract We already have end buyers. We have literally everything else clear. We're just trying to get a dollar amount to pay. And so in situations like that, our only course is really to get an attorney involved saying, hey, what do you want us to do? But we ended up probating actually at the last hour, and just the judge gave him authority basically, and now he can take that and become the executor and have authority to request.
That's crazy. So,
stupid.
Understanding your state laws, because they will vary from state to state, is extremely important to clearing title. So, looking at that, it's kind of the key piece to getting your title moved forward. So, working with an experienced transaction coordinator can definitely help save you some deals.
As far as services like Atlas, how much does a transaction coordinator normally cost?
The main question. It really it varies. It depends on who you work with. Us in particular can range anywhere from $450 out a transaction to $225 a transaction, just depending on if you do a lot of volume in business with us. And we're rolling out kind of a membership fee to where, keep in mind, y'all, about 20 to 30% of my clients' contracts fall through. It's the nature of the game. You're an investor, you're dealing with complicated deals. And so we still work on those files. So we don't charge for those types of things when they fall through. So we have like a small monthly fee, and then it's just your cost per transaction goes down from there. So I'd say anywhere from, I think typically in the US, you're going to see about 300 up to 500. And then in high compliance states like California, where you have to be licensed and do a lot more, I think they charge a lot more than that. And it's all paid out of title at closing too. So, the title company gets billed, you don't have to deal with it, and it just comes out of the deal.
Let me say that for anybody that's running a smaller shop, had you been around whenever I was running heavy, you would have been my number one source, just because TC is so important. And when you have 10 or 12 files, do you TC shorts?
I don't TC shorts, actually. I haven't had any, but I refer all my short sales out, really, because, you can still get referral fees off of them, and quite frankly, they can take months upon months upon months to do. So at the moment, I do not. Everything else we do. So, we'll deal with assignments, wholesales, owner financing, all of it. And so I find that most transaction coordinators, the reason why I became one is because when I was running my own business, I couldn't find anyone that knew what they were doing. And I didn't really have the funds starting out to really hire somebody full-time in-house. And what you find is a lot of people want to hire an admin for this role. I don't recommend it. You have to have a little bit of drive. You need experience, you need a little bit of drive, you need to know paperwork. I have so many clients that have fired their in-house TCs simply because they're not proactive. They're waiting for instructions where they're the ones that should be, pushing, asking, staying on top of things, making sure that we're asking the right questions. So
I love the price point too, because and especially with it getting paid out of title. So if you're like a onesie twosie investor that gets 1 or 2 contracts every couple of months, having a full-time in-staff TC isn't really possible. But at the exact same time, if you are the one trying to do all of the TC yourself, that means you're not out there getting properties. So it's really not putting you in the place of performing. So being able to outsource that to a company like this is pretty awesome.
Yeah, no liability. Y'all don't have to worry about the taxes on it. You don't have to worry about anything. And it's honestly, it's worth every penny, because if you saw the amount of hours that happen on a deal, those are hours you could be out getting more contracts at the end of the day.
So other questions we have popping.
Yeah, well, I'll give you my info. I don't think I have it on me, but I have something, yeah.
Do we have any questions coming in from the internet? Any questions from anybody here in the room? While we're waiting on that, one of the key things that I say, and I have to stress, and I believe we've said more than once, communication is the key to all of this. Like being absent with the title company, being absent with any of the lenders, being absent with your seller will let your deal start falling apart quickly. Communication means more on this part than anything else, in my opinion. And then having some sort of detailed process going in behind with follow-ups and making sure that you're just staying on top of the ball. You have to be extremely proactive, especially on pre-foreclosures. Like, it would not be uncommon for an auction to happen on a Tuesday and I'd get contract on Friday night. Do you have any idea at all how on top of the ball you have to be to get that deal closed when you have 2 non-business days and 1 half a day to get that deal done? You have to move and move fast.
I'll give you guys a fun story. Got a contract on Thursday evening. It's a foreclosure for Tuesday. It is deceased individual who has a daughter, has other kids too. The wife left 10 years ago and disappeared, but they were never divorced. It's completely, she's off the map. So we have a will and 2 documents that put guardianship for a grandmother over this child who has been willed the rights to the house. But guess who never filed the paperwork before they were passed? So now we have to deal with the legalities of not having, he just got it notarized and filed it away and didn't realize we had to go through an actual file these documents. So this is a foreclosure for Tuesday. Guess who's been on the phones between the title company and me and my investors? All 3 of us have been contacting everybody, talking with the lenders, getting attorneys involved to stop the foreclosure based on this situation, and we still don't have confirmation. So yeah, and that's one deal, and I hold about 35 right now.
So
it's
I've got one
important.
similar to that. So like, did you file a probate to get it stopped?
Well, that's what we're doing.
Yep.
So yes,
File
we
a
have to
probate
file a
Monday morning,
probate,
get it stopped.
but we only have 24 hours.
That's fun. So I had a very similar one. So like, it's Friday evening. That's why I mentioned that. It was Friday evening. I was dealing with a deceased homeowner. The daughter was living in the property. I'm meeting with the daughter. The daughter has a pissed off sister that lives in Oklahoma that doesn't really want to be a part of this. And the property's in foreclosure. And there was no will, there was nothing like that. And there's about $15,000 or $16,000 behind on payments. It's Friday night. Like, I don't have business days at all to get this done. Fortunately, I had a strong relationship with an attorney. I was able to get them on the cell phone real fast. And I was like, I need an abstract of judgment ASAP. Like, I need to figure out by Monday morning what's on title. I need to get all of my paperwork drawn up. I want to take this down subject to. I'm going to take it down subject to, and then Monday morning I get all this put together, and I'm still like, I don't have third-party authorizations on file with the bank, so the bank's not talking with me. The bank won't talk to the daughter either because the daughter's not on file to talk with them. Nobody can talk to the banks. So all I am doing is blindly, and I do mean blindly, working with this attorney, and I the morning of Tuesday still don't have an answer. I blindly just wired what I assumed to be the arrears to the bank. And I had probably not working, but I had the lawyer draft a simple cover letter to that and said the acceptance of these funds would basically be accepting that the foreclosure would be stopped. And then I had to wait like 72 hours to find out whether or not the foreclosure had actually stopped and I didn't lose my money. It was like 14 or 15
Gosh, I
grand.
have anxiety just listening to that.
But when, like, it was a gamble. It was a bit of a gamble. Like, we wired 14 or 15 grand in. My assumptions are is if they do foreclose, they're going to have to return it. My assumptions, like talking to the attorney, that's kind of how we worked it through. But there was potentially about $45,000, $50,000 in a win on that. So it's like, you know, I've got a potential $50,000 gain. I have a small chance of losing 15. I took the gamble on it, but like sometimes when you're out there and you're transacting this business, like it can get hairy and it can get hairy fast. So, so I had to get one daughter to sign an affidavit. The other one that was in Oklahoma, it was an iced over weekend. We ended up going up to Oklahoma in the ice to get the other part of the affidavit signed. And then on Monday morning, the banks went and talked to us because they wanted to probate. They wouldn't accept the affidavits of heirship. They wanted to probate. And it was fun.
So you really never know. And keep in mind that in a transaction, I look at transactions as being really relational. You can deal with 10 plus parties in a single transaction. That's not including if there's any heirs or other parties. Imagine who is the one person in charge of all that? Your TC or you? I mean, you're dealing with relationships with all these different people in such short amounts of time. You got to be a master of being able to get the stuff that you need. You got to make phone calls. I think that one that my husband and I had where the name was the same as the other kid and they were estranged, my title company tracked them down in another state and got them to sign within a few hours. And that's the power of a team, you know?
You need
I
to
don't
marry
know
the
how
title
she
company.
found him, but I was like, yeah, Nicole McGuire with One Nation. She's incredible. So she's one of mine. I keep several because you never know, but.
So something else that I have found from my side is once I get the contract done with the seller, especially on pre-foreclosures, what I have found a lot of times with people in pre-foreclosure, they're kind of like ostriches. They just stick their head in the sand and they're just like, everybody else will take care of my problem. They're not very proactive people from what I've dealt with in the past. That to be said, you're getting ready to close. You're like 3 days away from close. You're calling up the seller. Hey, seller, how are things going with the move? Move? What are you talking about, move?
I haven't heard from you.
We've got 3 days, you know, we're supposed to be closing, and they're like, oh, well, I haven't found a place to move yet. That is real. one of the things that I've had to deal with as a TC on my side is I need to call them up. Have you found a place to move? No, why not? Okay, well, let's go find you a place to move. What's your budget? You don't have a budget? What kind of couches can you live on? Okay, you can't live on a couch? What kind of car do you got? Has it got room? Do you have a storage unit? Like this is real stuff. You don't have a storage unit? All right. I'll go ahead and front you the $500. Let's go ahead and get 3 months worth of storage unit paid off. Let's get you a U-Haul over there, and I'll show up with some day laborers and let's get this stuff out of there. Now, I wouldn't expect Casey to show up with a U-Haul, but there needs to be communication there. There needs to be communication there. We need to find out, is the seller moving? If the seller's not moving, then somebody needs to be notified saying the seller is not prepared to move. We need to get things moving on that side. Or let's say there's some other hiccups that are involved, like the seller wants to get you need a death certificate from a decedent. Well, if I'm depending upon the seller to get that done, whether the seller is able or not able to do it, you can almost always depend on them not doing it. So you really need to just kind of become like, I would expect to get a phone call from Casey and it's like, hey, Kate, hey, I've been talking to the seller and they've been telling me for 3 days now that they'll get me the death certificate. Can you help me out with that? So me, as the person that got the contract, I will have to go to the seller and put the seller in my car and like, well, let's go to the public records. Let's go do this. Let's go do that. We're having a play date today. You're going to get some food on me today.
I have literally
It's
been
important.
in a foreclosure situation where, again, we were trying to get a city lien payoff and the city was not returning our calls. I'm talking like we must have made 50 calls, messages. No one was answering. And then I found out it was a loan program that was paid off. And I said, all we need is a release. And I called my seller and I said, get in your car right now. Go pick up your seller and take him here to this address, request this, have it faxed here. My seller said, Casey, they already told me 3 times they don't want to do that. I didn't ask you. I said, go to his house. And the seller, and by the way, the seller the whole time was cursing me out on his phone about losing his house to foreclosure, even though I already stopped it, and was being a pain, saying that it wasn't his responsibility. And all I said to him was, your buyer will be there at noon. And guess who got the payoff? Like, sometimes you just have to take control, so you have to be able to tell them exactly what to do. I have another situation where she needed an original of a death certificate. This is a client in Pennsylvania, and she was freaking out about it, and I said, listen, you can do this online, just order here, here, and here. I got a message last night with a confirmation that it was ordered. So you just got to guide them, and you have to be on top of it, and you have to know how to do these things. So it matters.
It can get wild. Like, if you want to be a real estate investor, you kind of need to put on your counseling hat. You need to put on your referee hat. You need to put on your boxing gloves. Like, it can get crazy. Like it really can. Like, you show up to some unusual situations. I've walked into several houses where it's like, this was not a wise decision for me. I probably should not be here right now. There's been plenty of times where I've been assaulted. There's been plenty of times where I'd show up to a property and you know what? I remember there's a chair flying through the front window. Just coming through the front window. Like, apparently the owner of the property was the father-in-law, and the father-in-law was renting it out to son and daughter-in-law, and son and daughter-in-law have been paying rent for the last 9 months. And father-in-law has been using that to go out and gamble. And when he showed up, the tenants have no clue that father-in-law hasn't been paying there. And whenever they find out that the father-in-law is there to show an investor the home to sell it, their response was, well, F you, I've paid you $9,000 in rent for the past 10 months. I'm going to get $9,000 out of this house. Boom, boom. I'm seeing holes popping up in walls everywhere. Like, they're screaming and yelling. It can get wild. So, like, the transaction coordination on that particular property was lovely.
Really
I was
fun.
having to pay off the tenants. I was having to pay off. And every time I go to pay off the tenants, like, they'd be happy. I'd talk to them and they'd be happy. And then they'd get on the phone with father-in-law.
Yeah.
And then it would all go back downhill again.
Yes, you're a mediator at the end of the day. I've had guns pulled on our notary at the closing table. I mean, y'all, it gets crazy. And that transaction, by the way, was smooth. Everything looked great. We had a little bit of difficulty in that they decided to pull out because they're talking to another investor. We solved that problem. And then lo and behold, we get them to the closing table and gun pulled, and we haven't heard from them since.
Joy.
So y'all got to be careful on that stuff.
I had another. I'll wrap it up. I had one more where we pay cash for houses. Anybody ever heard that? Yeah. I get to the closing company. This guy drives in from Abilene. Where's my cash? I was like, well, it's a cashier's check. Oh, you said cash. I expect cash. There ain't no cashier's check. I ain't taking no wire. If you don't get cash in the next hour, I'm driving back to Abilene. I'll sell it to somebody else. like I had to go to the bank, and if you've ever tried to pull that much money out of a bank that fast, they're like, well, we need you to sign off on this for the IRS. Well, great, now I'm getting reported to the IRS, and like I'm walking in, I'm like, I'm not about to get robbed here. I called up a couple friends, and I'm like, well, let's go over here. And Shiloh, my title escrow, she's like, we can't do this, and I'm like, can you get him to sign a release saying that he'll release his funds to me? So he signs off the release of funds to me, and she's like, I'm leaving the room. So we're sitting there on a conference table just counting out hundreds. It's like stack. It's a table like 9 foot long, just stacked in $100 bills. And it's just like, he's like, she's just sitting there smiling. He's like, all right, good to go, but we closed it.
Yeah, and it happens more often than y'all would think. Like that's just what, like setting the expectation for your seller is everything. Setting the expectation for the process, as well as the definition of cash, because I run into that more times than I can count. Like I don't even know. Like you think common sense is common, it's not. So you have to be the person that has the patience to explain. So set the expectation.
Awesome. We've got a question from the internet.
This is from earlier, but if you have a contract on a property, how can another wholesaler or an investor get the same contract on the same property?
They simply
Seller just signs it.
signs it. I mean, it doesn't matter.
The seller does not necessarily know the law. The seller may not necessarily care about the law, but the seller's only goal is to get the home sold. And if somebody else walks in behind you and says they'll do it faster for more money, it's going to get signed.
It's true. And that's why memorandums are important. And we've had a situation, we had a seller that tried to sue us because they signed with 5 other investors. We were the only ones that filed a memorandum. So we ended up releasing it because it was a newer investor. We taught them a lesson, and I think my husband sat them down and said, next time you need to do this, this, and this. But it happens, and there's no guard against it.
Is there a place or somewhere that you can get a checklist of everything you need to get done online or somewhere for closing?
Not available through me yet. I had one that I kept. The way I'd run my back office, which wasn't really probably the most efficient, even the fact that I'm standing up here as the co-founder of a software company, I am kind of anti-software. I ran my entire office with manila folder, and I would have a TC sheet that would go on the front of every one of those manila folders. I'd staple it on there, and it'd have a long list of checklists. So I'd sit there and I'd have a filing cabinet next to me, and every time I'd work on a file, I'd pop it open, I'd grab the file for that property, I'd look at the checklist on the front, I'd have a log of communication in there, and that's how I ran everything from the back office on my side.
What I'll do is I have a Facebook page for Atlas Transaction Coordinator Services. I'll post something in there for y'all because I have several. So
that means go like Atlas Transaction Coordinating Services on Facebook, and you'll get a copy of it there.
Absolutely.
What is a memorandum?
Microphone to that side of the room. A memorandum of contract is what we're basically it's a simple document. It says that the seller and this buyer have agreed on this date to sell the property and close on XYZ date, and we notarize it, and that's kind of it. And then we file that in public record, and that puts the entire world on notice that there's a contract between the seller and myself, and that no one else should be closing it. But it doesn't necessarily mean that it won't. I've seen title companies close around memorandums.
Yeah, it's not foolproof, but it helps. Did you have a question?
So I have a current contract on a property where the owner on title is not the resident. The father is the resident, and they're estranged. The father's been there for numerous years. The bank has sold the loan in a portfolio to another bank, and the resident, the father, has assumed identity. So, and he's, like I said, he's estranged. He's not willing to show the property. He said he'll shoot anyone that walks on the property.
Okay, so you're in contact with the owner,
Correct.
But the resident there is causing a lot of problems.
Correct.
So this right here, you get your contract with your owner. What I would do is I get the contract with the owner. I get title started on it if you haven't already done so. And then from that point moving forward, it's going to be really between you and the buyer and how much of a spread you have on that. Like if I had a really fat spread on it, I'd probably, if it's a $100,000 spread, I personally would probably close on it without him even knowing it. I'd just go ahead and buy it. I'd leave him out. And this is me. I'm not by any means giving you advice. I'd just go ahead and buy it if there's a $100,000 payday on it. I'd buy it without even talking to him. I'd make sure I have insurance on the property the day I buy it, and then I'd start the eviction process. And if he does destroy the property, he destroys the property, but I got a $100,000 spread and I've got insurance.
Okay, what if you're trying to wholesale it and you're not necessarily
On a deal like
buyer?
that, find the buyer that's willing to do that. Because when you've got a spread that,
they'd have to buy it sight unseen.
Well, if there's a $100,000 spread, I mean, kind of yes, kind of no. I mean, that right there becomes a gamble, and you've got to find somebody that's willing to take a gamble on it like that. Other than that, you're gonna have to get them out of the property prior to. And to do that, then you're gonna have to work with the seller and an attorney and get an eviction done, and then run the risk of the property getting burned down in the meantime, and then all of the drama in between. But on my side, it would just really depend. Like, it's gonna become Jerry Springer.
Be prepared.
Yes, sir.
Casey, I had a quick question. Going back to the 4 other wholesalers, investors come behind me after I get a contract signed, how detailed do I need to be on that on my assignment? Is it down to the timestamp so that it differentiates if 4 other people, if we all go on the same date?
You mean on the memorandum?
Yeah.
Yeah, so it's when it's filed. It comes
Okay.
down to whatever's filed first.
And same date, so then by that time, do they go off of the actual time?
I mean,
So as far as my understanding goes, the date of the contract is who technically has the contract. Anything past that would be, and I don't want to use the wrong words, and it's not tortious interference of contract, or it would be on the seller, because the seller may have not even told the other 4 people.
Gotcha.
It's not like they're necessarily being malicious with it. The seller is in fault right there. But the first contract signed is the legitimate contract. Now, when you're filing a memorandum, the only thing that matters about a memorandum is the day it was filed, the time. Like, if you file a memorandum at 10/31, but you were the 5th person to sign contract, and you were the first person to file a memorandum, well, your memorandum's kind of in there and it's time stamped. But that doesn't really mean much, because in my opinion, it's the contract that dictates who's truly in contract. So the very first contract is the one that's in contract. Everything else past that is either a fault of the seller, or it's all a fault of the seller. The seller signing anything beyond that is kind of against the rules.
and sometimes, honestly, you can go by the legality of it, and they're still not going to close with you, and they're going to be stubborn. So you have to decide whether you want to have someone pay you to lift that memorandum to take the contract, or if you just want to wait it out.
Memorandums can get you paid, but at the exact same time, like I mentioned yesterday, which is sad, there's a new trend where people are actually marketing to memorandums in the sole attempt to, like, people file, this is sad. People file memorandums to secure their interest in title. People know that their title companies will close around memorandums, so when they see a memorandum filed, they will go straight to the seller, try and get it done, and they'll just try and beat you to close. And then be like, sue me.
Yeah. It's
It's sad. So we got to wrap up. We have any final questions? We'll take 2 more final questions if we got any in the room. If not, we're going to wrap up with this segment and move on to the next piece. All right, good stuff. So did you start seeing how fun this can get? Yes. One of the key things about being a wholesaler is you need to kind of be a jack of all trades. You need to understand a lot. This is probably one of the deepest parts of the business. Like, if you want to be a landlord, going out and getting a conventional loan, buying a house, and then putting a tenant in there, while it has its nuances, is somewhat straightforward. Wholesaling, you really need to understand this business. There is a lot to understand about wholesaling. While wholesaling is an opportunity to start out with limited to no capital, it does take a considerable amount of experience. And that's why I keep telling y'all, take 9 months, get in 100 houses, call 1,000 people. Got one question from the internet.
Yeah, one final question, then we'll wrap up. When you do get a memorandum of contract, where do you take it? How do you file it?
You file it at the county clerk's office.
Or your
Costs like
title
33
company.
bucks.
Yeah, or your title company, either way.
Title company will file it for you.
Yeah, but you will need to give them the original most of the time, because it has to be notarized. And your title company can notarize it for you, so just drop it off to them and they'll file. Some charge for it as well, and some don't, depending on your relationship and how much you do.
So there we go. So that right there was transaction coordination. Moving up next, do you have any final? No. Let's have a round of applause for Casey. You want to tell anybody how to get in contact with you?
Yes, if y'all want to get in contact with me, I think I have a few cards, but the best way is Facebook, Atlas, Transaction Coordinator. What is it? Services. Oh my gosh. It's my day off. And my website is www.atlastcservices.com. You can also just reach me at Casey, that's CASEY, at atlastcservices.com. So if y'all have questions or want more information, our current pricing that's on the website will change in the next few days, but just shoot me a message and I'll let you know.